the judge panel. Let me introduce our judges today. To my far right is Judge Andrew Hathcock. He's an associate judge in Travis County and has been for as long as I remember.
15 years?
15 years. And this is Judge Karen Crump. She is the district judge in the 250th Judicial District, and this is her staff attorney, Mr. Valera. Bahara. All right.
Sorry.
I'm sorry. So, if you all want to stop and ask questions during this, I would encourage you to do that. I've got a list of questions here, but these are always really good if you'll stop and interrupt and ask what's on your mind. The first question we'll have is Mr. Vavra earlier today suggested when we come in on a VLS case, we tell you it's a VLS case. And why should we do that?
Because you'll get heard faster. That's the best answer I can give you. If we have a central docket system, and so all the cases set on the family docket for that day all appear in one courtroom, and you call through them and you make your announcements, and then you get assigned out to judges as we have judges available. And so if we know it's a VLS case, we will try to get you in and out as quickly as we can, because and this is a good segue, is something I wanted to say at the outset. We're very appreciative of your service and your willingness to do this. It really fills a tremendous need, and it helps the judiciary, and it helps your clients. And I don't know how many of you have done family law before, maybe not at all. And this is a lot of information to absorb in one sitting. It's like drinking from a fire hose. But I promise you, as much at sea as you might feel, your client would feel even more at a loss without you there with them. So they are, I guarantee you, far, far better off having you there representing them and helping them with their case than they would be trying to fend for themselves. And so we really appreciate you all being here today and being willing to do this. It serves a tremendous need. So thank you.
I can't necessarily promise that saying that you're a VLS lawyer will get you ahead of anyone else, because sometimes I don't have the ability to do that. But I will say that by saying you're a VLS lawyer, it speaks volumes to me about who you are and why you're doing what you're doing. I did a lot of pro bono work in my practice. I practiced for 17 years before I came on the bench in January. And it was from the day I was licensed, the first thing I said was, how do I sign up to do pro bono? It's really, really, really important to me. So whatever is coming out of your mouth, I know comes from the perspective of someone who's doing that for good. And that means a lot. It really does. It brings goodwill. And whenever possible, I will try to get you, I will have in the back of my head that you are doing this on your own dime, so to speak, and try to get you reached as quickly and efficiently as possible. But certainly, to me, it tells me this case has been vetted by VLS. This case has been looked at by someone willing to give their time to this person. That means a lot. It really does. So I echo what Judge Hathcock has said, and I appreciate that you're all here, that you're all willing to take cases, because so much of what we do involves pro se litigants, and it's so overly complicated and difficult because they don't have people like you who are willing to help them, even if it isn't your area of specialty. The fact that you're a lawyer and you know how to handle a case is so helpful to them. And so absolutely I want to know about it. I often don't know about it. Sometimes I don't find out until we're in the middle of trial and digging in a file, because some people don't want to push that on the court. But it is important, and I urge you to let us know if you are.
I have a question for you, and that is if, or any of you, and that is if you are doing cases here before y'all, and the other party is pro se, what kind of suggestions would you make to us as attorneys for one of the parties? I mean, you've got to represent your client, but at the same time, you want to make it go smoothly for the court so it, proceeds. Any suggestions you have in that regard?
Dealing with a pro se litigant?
Yeah,
Just really how to do it? It is an art in itself, and I think we could take a full day just tackling tools of how to do that, because it's really difficult. And I did it as a litigant, and I've done it as a mediator, and as a judge. And it's hard. It's hard to try to equalize and balance out the power that is happening there, and also as a litigant to try, and Shane can talk about this too, but to resist the temptation to try to help them. And also to be fair to your client, to be candid with the court, and to help the process. It is a balance. It's tricky, and there is a risk in doing it, because anytime you're giving anything that resembles advice to someone who's pro se, you could cross that line and provide legal advice to them where you shouldn't be, even if they really need it. So the first thing I always suggest is to get them or direct them to the Texas Family Code and say, these are the rules that as lawyers we have to follow. And I suggest that you look at the rules and look carefully at them, and here's where I can direct you. And sometimes they just need to know where to look, and we have the law library that is really good. And so really recommending that the other side go and have the resources available at the Texas Law Library is really a good idea if you're dealing with a pro se on the other side, so that they can at least have some basic resources so that you can negotiate with them, so that you can have an intelligent conversation with them about what truly they have rights to. And I brought Mr. Bahar with me because as my staff attorney, and all 10 of the district judges have a staff attorney, and our staff attorneys can help facilitate pro se litigants with you all sometimes. They are the gatekeeper for the court, so that we don't wind up in any type of ex parte communications. They deal with those communications in a really tremendous way. And sometimes you can talk to the staff attorney of any of our courts and say, here's the, as long as you're copying the other side, lawyer or not, here's the situation we're in. Can you direct us to what would be a good way to handle this? And that is perfectly appropriate, and is something that we do a lot. And our staff attorney is really happy, all of our attorneys are happy to help facilitate some of those difficult situations to the extent that we can. And you can talk a little bit more about how you deal with those.
It's a difficult issue because you don't want to be the lawyer for both sides, but you do want to kind of make sure everything moves forward efficiently. One thing I've found helpful is, and we will, the court sometimes will ask that I be there just so that one side's not getting, there's not any overreaching, or the unrepresented side's not kind of being pressured too much or not understanding, so that can kind of help facilitate there. I think if you're able to walk through the proposed disposition of issues and really walk through with the other side, is there an agreement here? What's the problem on this particular issue? Get their perspective so that you're not just walking in blindly and not knowing what their response is going to be or where their case is coming from. Then you can really walk through the case a lot easier. I've seen that's a really helpful way to kind of help understand what the issues are going to be on the other side. It's a delicate balance, not when the other side doesn't have an attorney, but I think that's a really helpful way to get their disposition of issues, understand where they're coming from in an articulate way, and then also go through yours and see where the real disputes are, and see if you can really, a lot of the times after you do that, you're able to resolve a large majority of the case.
In VLS cases, if you're the only lawyer, sometimes the other side will believe that you're the lawyer for both of them, and it happens. You're nice, and you're the only lawyer. Can you just help us get our documents together? And you can't do that. The Texas Supreme Court has said you can't do that, as much as you'll want to, because you wouldn't be here unless you like helping people. And so there is, you have to draw a line somewhere in how much you can do to help the other side. But I do feel very uncomfortable when there's one lawyer in the room and the other side is pro se. And so I do use my staff attorney just to sort of monitor and make sure that everything, both for the protection of the attorney and for the protection of the other side, because you never want to be in a situation where the other side said that you did something or were overly coercive in the negotiations. So.
And that should be a question you ask and approve up. If you've been negotiating with a pro se person and you have an agreement, you want to get in front of the judge and say, sir, I've been talking to you out in the hallway, and I told you you could get your own lawyer and should get your own lawyer, and you reached this agreement, and you understand you had the right to have a lawyer. You want to be as transparent in front of our judges as possible. And they always get that it's a fine line for us, and you need to be very, very careful. I would only communicate with pro se people in writing. I have a standard paragraph when I do that says, I ain't your lawyer, go get a lawyer. Nothing I say to you is legal advice. You should get an independent consultation of whatever I've sent you, and that's the best way you can protect yourself.
Absolutely.
There's been some questions about protective orders and family violence. So I'll start with you, Judge Crump. What kind of evidence are you looking for in granting a protective order, and particularly in cases where there's not overt violence? It's more gray area threats. What are you looking for when you grant a protective order, and what kind of gray area cases would you not grant a protective order on?
The statute is clear on protective orders, and I didn't really know that before I took the bench because I didn't spend a lot of time doing protective orders. And in Travis County, our associate judges do the protective order docket, and so are intimately familiar with how those go. As a district judge, I see them rarely, and when I do, I expect that the evidence is very clear, that there is clear evidence that there has been, and you could probably quote the statute, but that there is a likelihood that it is, well, not only that it's happened, but there's also a likelihood that it will happen in the future. And it is, those two aspects are difficult. And if you can't get both of those aspects, then I can't grant a protective order, and I won't. The county attorney's office handles the vast majority of those. And so there is a level of comfort knowing that they have spent a lot of time investigating these cases. They're difficult. When I see them, there is typically sufficient information to allow me through affidavit and other evidence to determine that it's actually taken place, that it's necessary, because it's likely to occur in the future. So beyond that, I think you should cover that.
Yeah, there's two elements: that family violence has occurred and that it's likely to occur in the future. And I think the important thing is the definition of family violence. It's physical violence or a threat of physical violence. So it can't be, a lot of people are going to engage in very bad behavior and name calling and very emotionally abusive behaviors. That alone will not be sufficient to get a family violence protective order. It might be sufficient to get lots of other kinds of relief, but not a protective order. There are also protective orders available under the Code of Criminal Procedure based on stalking behaviors. The parties have to have a certain relationship to each other, and that probably won't be a difficult thing in the cases that you're having. They either are in a dating relationship, they might be married to each other, or they're the parents of a child together. But they have to be members of the same household. So that's, it's, a lot of people say, well, it's a he said, she said kind of thing, but, we judge the credibility of witnesses, and so it's not necessary to have corroborating evidence to support it. It can be supported by the testimony of the applicant alone, if it's credible. So it helps to have, certainly to have corroborating evidence, especially when credibility might be an issue in the case. It's not necessary that someone have called the police to support their claim, or that they have sought medical treatment or anything like that. But the evidence about those things will generally be admissible.
I'll just add that protective orders, I don't think they should be taken lightly because, as you mentioned, there are other avenues, other ways you can get relief through temporary injunctions and temporary restraining orders and temporary injunctions. The protective orders place a significant, they affect people's lives significantly, and so I think all of us take them very seriously. It prevents people from sometimes getting a job and keeping guns in their household and being near schools and, things that actually affect their day-to-day lives. And so to me, it comes down to clearly following the statute and reading, ensuring that the parties can actually meet that burden. And if they do, they get it, and if they can't, then they have to look at other means to protect themselves from the bad behavior or the alleged or purported bad behavior.
In a VLS case, if the opposing party is a foreign national and is in a country that may be difficult to serve them in, what kind of substituted service, and I guess this is probably a question for you, Judge Crump, what kind of substitute service are you willing to approve to serve somebody in, say, Mexico or El Salvador or India in lieu of actual personal service?
Well, we talked about this a little bit before we started, and we get requests for substituted service during our uncontested docket. So I don't know how familiar, I think Warren talked to you guys about the uncontested docket 8:30 and 1:30 every afternoon. We rotate out the 10 district, or 9 of the 10 district judges rotate out, and so we do get a lot of requests, both from the family law docket and from the central docket, of people looking to try to serve people. They've attempted, sometimes because they're out of the country or just because they can't tag them. And so we have to really look and see if you've taken all reasonable steps in order to personally serve them. And we'll look at whatever means you show to us to make a determination of whether or not they meet the statute and they're reasonable. So sometimes I've seen process servers in a foreign country, I've seen email, I've seen FedEx, I've seen, what else have we seen?
Occasionally there's service on not that particular person, but someone they're related to that would reasonably give that the party notice of the suit.
Posting international journals or publications, those kinds of things. If they're, I don't like publication because in all reality, it's highly unlikely that that person who you're trying to notify is actually going to see it. So that has to be really a last ditch effort. But if you know where these people are, think creatively. How Facebook is a possibility. If you know and you can show to me that they've been using Facebook, they have an account, you can prove to me that that's their account. You have someone to testify or some affidavit to show that's the Facebook account that I've been interacting with this person. I know he's in Guatemala, but he's using Facebook. And here's all whatever you can do to show me that this effort is reasonable and that they are likely to actually receive notice, then bring it to us. Let us know the reasonable, normal efforts that you've tried, and then get to that level. So, first personal service, and then trying to serve a relative, and trying to use FedEx and certified mail, and whatever you can do, just show us the steps that you've taken, and if they're reasonable, we'll allow it.
Now, this is just one example of creativity. Had a CPS case years and years ago, and one of the parents was cited by publication. Of course, then you have an attorney ad litem appointed. And this lawyer contacted the Honduran consulate in Houston and learned that Honduras at that time had a national radio station. And they were able to put an announcement on the radio looking for this person. And people responded who knew this person and knew where they were. So it's amazing sometimes what you can do. And that was way before the internet or anything like that. So there are lots of creative ways you can try to find people or track them down.
And typically, if someone's asking, they're bringing a stack of, here are all the 99 ways I've tried to get them.
Several of us here work for organizations that deal a lot with immigrants, and a thing we get a lot is, well, we know what town they live in, but there's no street addresses. But if you can send mail to the post office and put their phone number on it, if you can get some sort
I've
of.
had that.
Okay, and if, so you can get someone who asserts that is the only way.
Yes.
Things, that's great.
As long as it's credible, and, you know, and I actually had that circumstance, and they said, and 3 days later, somebody from the post office called me back and said, he's been here, you know, and those are meaningful. That's meaningful information to us, because it says that you're not just throwing it out there and there's no likelihood that this guy or woman is going to be notified of the litigation. These are real steps. These are reasonable. And what's reasonable here in Austin is different than what's reasonable in Honduras. It just is. And we'll look at the circumstances that you're looking at. And as long as you can demonstrate that that's the best way to do it, then we're likely to approve it.
We had a question earlier during one of the child custody presentations about the presumptive residency restriction being Travis and contiguous counties, and somebody asked, what does it take to make that a smaller jurisdiction? And I thought that was a good question, because I have noticed it has been shrinking the longer I've been doing this and the faster Austin is growing. And so I guess I would ask each of you, is Travis and contiguous still the standard, or is that actually not the standard anymore?
It's the default, and it certainly, Travis is the default here. And from there, just speaking personally, because I don't know what the other judges do on this, but personally speaking, I would want to hear some evidence of why it should be something different. I have approved a requirement of a high school zoning area, or a school district zoning area. I have approved 2 different elementary school areas. You know, if really that's something that I like to hear. A lot of people come into my court and say, Travis in contiguous county is just too big. We can't get from South Austin to Round Rock within 3 hours, you know, and it's true. You know, that's a fair complaint. And so I'll always hear why they want it limited and whether that's going to be in the best interest of the child. I don't think it's in the best interest of a kid to be driving back and forth in 3 hours of traffic 2 or 3 times a week. That's just not a good idea. It's not safe. So if there's a way to limit it and still be fair and not unnecessarily restrict where someone lives, then you know, I'll certainly entertain it. How about you?
Yeah, I think I want to distinguish, there is no legal presumption that I'm aware of. So it's customary, I think that would probably be the best way to say it, is that kind of, it's a common order to say Travis or contiguous counties. And I haven't been asked very often to do something other than that. Occasionally, I've had people agree, we want to stay in this particular school zone. That's usually the most common alternative. I've had people sometimes say within a certain range of, you know, a landmark, within 10 miles of the state capitol building, or within something like that. But it's so fact-specific that it's really hard to articulate what would really be good cause to do that. And then I think it might depend on whether this is a temporary order you're seeking or a final long-term order. I think that could make a difference too. I might be much more willing to be much more restrictive on a temporary basis than on a permanent basis. Now, even if a restriction is put in place, it can always be modified. And so the custodial parent who's under that restriction can come back to the court and say, I need permission to change this because X, Y, and Z, and if it's a good reason, then that could be modified. So it isn't necessarily set in stone.
And I was going to say, I think the code requires for one conservator to have the right to designate primary residence of the child. Doesn't necessarily require geographical restriction. We've seen cases where one party is consistently moving all over the place, whether it's in Travis County or from city to city, and those are probably reasons, compelling reasons to want to kind of box somebody in to make sure they're not moving. And they have gone from small areas, school zones, all the way to certain cities or zip codes. We did get one case that I wanted to bring up, and the client, I guess they just pushed through their divorce decree, and at the time the parties were living here in Austin, but they're finishing up their divorce in Dallas, so they just got in, it said, I believe it said Dallas County. And no one ever thought anything about it. They both lived here in Travis County, and then an issue came up on modification where mom wanted to move to California, and she says, well, you know, I'm the one that has the right to say where we're going to go, and although we've been in Travis County, it said Dallas, and I'm going to move to California. I have the right. And it became a really big issue, so you do want to discuss with your clients, what's the foreseeable future look like? Are you going to really be in Austin or Travis County? Right? Are you there right now? Are you planning to move? Do you have a new job? Because those things do come up, and they're very concerning, big problems.
And I like to see in those decrees a lift provision, because of that being one of the reasons. You know, so if the decree states that the primary parent has the right to establish residency in Travis County, then the next paragraph needs to mention, but if the primary parent, if at the time that the primary parent wants to move, the other parent doesn't live in Travis County, then the requirement that he or she be contained to Travis County be lifted. That way, you don't have someone unnecessarily bound to a county where nobody lives. So the idea, the purpose behind that is so that the children can always be reasonably close to both parents. So that's why we have it there. It's so that, you know, the child can be close to both parents. It has nothing really truly to do with limiting where the parents live. It's limiting the child to an area so that both parents can see them regularly. Yeah.
Have you guys seen any cases requiring access to internet? It's had a student whose parent, you know, the child lived in another state, and they wanted them to be able to Skype with them.
Uh-huh.
And the mother didn't want them to use the internet at night for a variety of
Yeah.
reasons. And
We do.
okay.
We do. FaceTime
Yes,
and
everyone's saying
Skype
they have to let them
and
use
telephone.
internet calling.
You want to talk about that?
Yeah, I
see
mean,
a
that's a
lot.
very common provision to have electronic access when not in possession of the child. Now, you know, you might start with saying reasonable. What's reasonable? One parent says, well, after 8 o'clock, that's not reasonable. And if parents can't agree on what that is, then it may be necessary to really micromanage it. You can contact the child between this hour and so forth. But generally speaking, I mean, that's a very common provision to have enable electronic access by phone, by Skype, by FaceTime, whatever it is.
And it's because people quarrel over what's reasonable. I mean, because some people have, you know, in one household they might have a very consistent, clear 10 p.m. bedtime, and in the other house the kid gets to stay up as long as they want, and the parent who doesn't live there wants to be able to call them. I know they're up. I want to just call them and chat on FaceTime and Skype. And so sometimes we do have to micromanage because they just can't agree as to what's reasonable. And I've done, you know, you can have 30-minute FaceTime or Skype conversation for twice a week for 30 minutes between 7 and 9 p.m. I mean, we do that. We don't like to do it, but if, you know, if they can't agree, then we will, because, you know, it's any access to the parents that is reasonable is good, and we want that interaction with both parents when they're not all, you know, when they're not together. So we'll do it if we need to.
Clients will come in and tell you all about their case, and it becomes abundantly clear the only source of information they have is what the child has told them. And so as far as child hearsay statements, how much and are you allowing that into evidence? The kids told me X.
I only allow children's statements when it has to do with alleged abuse or neglect. I think that's the only way we're permitted to allow it in. That's at least my reading. It does, lawyers try to bring it in a lot, but it's not reliable information. It's hearsay. It just is. And so unless it has to do with the really excited utterances coming from a child in the middle of something, some very tragic event or an abuse situation, then I don't typically allow it in. Of course, we do, under special circumstances, interview children in chambers when if you can follow the guidelines of the code or both parties are in agreement. It's not really something we like to do unless it's really necessary. But you want to talk further on that?
There is an outcry statute in the family code, and if you can meet those criteria, then it should be admissible, or if it's an exception to the hearsay rule and the rules of evidence. But otherwise, I'm pretty strict about applying that. And now, if it's, something that the child is expressing their feeling about something, it's not to prove a fact, I generally am pretty lenient about letting that in. But it kind of goes to the weight. How much weight am I really going to give that? Then interviewing, say, while we're on that,
Yes.
about interviewing kids. And I know this has been said before, I'm going to say it again because I don't think you can say it enough. And do not bring kids to the courthouse until everything has been arranged with the court in advance about when that's going to occur. The courthouse is not a child-friendly place at all, and we don't want to be pulling kids out of school and have them sitting around. And so, but if the child is old enough to be express their view in chambers, we will make arrangements to do that. I talk to kids all the time, and but we want to make sure we do that in a methodical way, not in a chaotic way. So tell your client if they're school age, they just need to go to school that day. We'll make an arrangement. I might stay late until school's out and then bring them later, and I'll talk to them late, or we'll do it at the lunch hour or something, or we might do it even another day. But we'll make those arrangements, but don't bring them up front.
And I'd even go a step further and say, actually tell your clients, do not discuss litigation with their kids. Please do not, and you all need to be the ones who say, do not discuss litigation with these kids. Do not let them know that there's a possibility that they'll be testifying unless there's been a court ruling that they should testify or interview in chambers. It's just too stressful for children. It's so incredibly stressful on kids. And then them actually appearing in the courthouse is just inexcusable. And it's happened to me. I know it's happened to you. And it happens in the CPS docket all the time. And children need to be in school. They need to be in school unless it's absolutely essential for them to be in a courthouse. So that I would just add that as well.
We see cases where, and I think you'll see a lot in VLS cases, where the children will refuse to go see the other parent, even though there is a court order that says that has to happen. What do you think the obligations of lawyers are in that situation? And what do you think obligations of parents are in that situation? And is there an age where, you may not enforce a possession order because of the age of the child? That's 3 questions, I believe.
That's a really, 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 really hard
Yeah.
one. I mean, it's fact intensive. The reality is that we do see a lot of teenagers that sometimes don't want to go see a parent. And I don't know, I guess it's probably around 15, 16, 17 where they're driving, or 16, 17, they're driving on their own. And it's kind of hard sometimes for some parents to enforce those things. But I think what I could suggest to you all is to communicate to your clients that it's really important to try to follow the orders as best as you can. Writs of attachment where a sheriff is actually going to get a child is horrible. It's horrible. I don't like to see it. I don't like to sign them. But sometimes the facts require it, and if necessary, a sheriff might be involved to try to get a child. But it's the worst case scenario. You never want to have to do that. It's traumatic, and it's not good for anyone, particularly the children. So I think what I like to see first is trying to deal with the root of the problem, trying to figure out why a child's not going to see their other parent, and that usually involves some type of therapy. And the domestic relations office is really good They have a lot of resources, a guardian ad litem, therapy, parenting classes. Why is this child fighting so hard? There could be more to the story. And so I try, I often get them at final. I know Judge Hathcock and the other AJs see it earlier on in the process of when this might be happening. And I know that we try in those situations to try to get other resources involved so that we don't ever have to attach kids, because it's not a good thing in my opinion.
Yeah, I think that's definitely true. I think I don't know that there's a magic age, and I think it depends a lot on why the child doesn't want to go and what it exactly is they're saying. There are some parents who just kind of give in, and the child says, well, I just don't want to go. Oh, okay, well, I'm not going to make you.
Mm-hmm.
But if the child said, well, I don't feel like going to school, I'm just going to stop going to school, we wouldn't accept that. And so unless there's some really good reason that the child's safety is at issue, then the parent ought to be being the parent and saying, I know you don't want it or like it, but you're going to do it because I'm telling you, I'm the parent. Now, if the child's making an outcry about abuse, then you've got an obligation to report that to Child Protective Services and have them investigate it and then take appropriate safety measures. But if it's simply a child saying, well, I don't like to go because it's interfering with my personal life or schedule, that isn't necessarily a valid reason. At some point, kids will get big enough and strong enough and fast enough that a parent can't physically wrangle them into a car or make them go. But that's a very specific determination. And I've had several of these recently. I don't know why they seem to come in groups, but I had, when kids are running away and threatening to self-harm and do those kinds of things, and that's pretty serious, and we take that seriously. Sometimes it's just because the parents are in such conflict with each other that it puts the children into just unendurable stress, and they just can't handle the back and forth under those circumstances. And they're telling you something. If they really are putting their foot down and they don't want to go, they're telling you something. And so I agree with Judge Crump, absolutely. The best approach is to try to figure out what is going on here, and is there a way we can fix it so that the relationship can improve and get better.
And one of the things I would encourage you all to do is think of yourselves in the counselor role, because something you touched on is that the little ones that fight going to the other parent because maybe it's just not as fun at the other house, maybe they just want to be closer to the kids across the street. Encouraging and communicating with your clients about the importance of a court order, and really having, letting them know that document it's essential to follow the document without an agreement. And without doing so, a parent can come to a child and say, it is your time to go to your father's house, and we're going to go. And it is just like going to school in some ways. It's just not an area where there should be negotiation. And I think that many people, particularly in a conflict situation, they want to do what their kids want because they want to be the parent that the kid likes the most. So, a lot of parents think, well, if I give in, then they'll like me more, and then they'll pick me in the end. And so that's a conversation you can have with your client, that's inappropriate behavior, and that it's really important for the child to see both parents and spend quality time with both parents. And at the end of the day, I think all of us really try, unless there's circumstances where it's inappropriate for a child to be spending time with one parent, then that's always our goal. And so that's always going to be what we're going to try to enforce. And so,
yeah, and I think that's probably, as an attorney, your first maybe intuition or reaction is, I'm going to file a motion for contempt or a motion to enforce, and that might not always be the best first step to getting the visitation that is going on. I think those other steps a lot better to kind of reach out and talk to the other parent. I mean, you're the representative for your client. There's no problem with you getting on the phone and calling the other parent and letting them know and trying to negotiate what's going on with the child. But we do get those a lot where dad didn't show up with the kid, or I didn't get the kid on day 1, day 3, day 5, throw the other parent in jail. And like, that's not really something that's gonna resolve the issue. It's not gonna be helpful. So that, hopefully that's not the initial reaction, but that does come in front of the court a lot.
In a VLS case where one of the parents is incarcerated and we're representing the non-incarcerated parent, and we know that the parent's going to get out of jail in a year, maybe 18 months, 2 years, do the courts want to see a possession schedule in place for that parent even though they're incarcerated if it's a default order? Or should we simply say no possession, that parent's going to have to come back when they get out? I struggle with that one from time to time.
Yeah.
Well, again, I guess the lawyerly and glib answer is it depends. Right? But what does it depend on? I mean, why are they in prison? How long are they going to be there? Or are they just in jail for a short period of time? Why are they there? Has there been an established pattern prior to their incarceration of how they interacted with their children? And was there a possession schedule that worked pretty well? And maybe there's no reason not to go right back to that when they're out. How old are the children? What kind of relationship do they have with this missing parent? Is there going to need to be some kind of time to reacquaint them? And so the further out there is, the less predictability. I just like making contingent orders because they're subject to differing interpretations. One party says, well, the contingency's been met, you need to do X. No, it hasn't been met, I'm not. It invites dispute. And we don't know what things are going to be like at that time. So I think my preference in a vacuum is we'll make an appropriate order at that time. So when that person gets out of custody, they can come back into court to explain what their circumstances are. Because where are they living? Do they have a safe place for a child to spend significant time with them? Where are they? What city are they going to be living? Is it close? Is it far? So it's very hard to account for all those variables without knowing more. And I think we could in a better position to make a better order for the children if we just look at it at that time when circumstances change. So I'm, open to saying, well, we're just not going to have any possession other than by agreement. The parents may well agree once the person's out, yes, this will work. Come back and we'll make an order at that time.
I would say that it's my preference to have an order with contingencies because I don't like to have the parent who's not incarcerated have the burden of coming back. I think it's good for whatever reason that person has been incarcerated. If it's a violent crime or if it's a little different from incarceration, but if they're suffering with serious drug or alcohol addiction that endangers the children, then I would see at the conclusion of their treatment or incarceration a step up in visitation, and once those contingencies have been met, then to stage 2, and let the parent who is incarcerated come in and say that those are not appropriate at the time, because then they could come back and say, well, I completed my sentence, it was for theft, it had nothing to do with my parenting ability, and I have a great relationship with my kid, I've maintained that relationship while I was in jail. They could come in and explain why there should be more time and why at a later date. But I prefer to see the parent that didn't do anything wrong not having to return to court unnecessarily. If the other parent's not likely to comply with those contingencies, then, and as long as they're reasonable, then allow them to fail and allow them the burden to come in and explain why they didn't meet those contingencies or explain why they should have more time than allowed.
As I understand it, there are more requests for guardian ad litems than there are guardian ad litems available. Is that a fair statement?
Yeah, I think that's true.
So what is it, when you all are deciding, am I going to appoint a guardian in this case or not, what information can the lawyer bring to you to convince you that, yes, this is the kind of case that is going to require a guardian? Even though probably all cases, frankly, require a guardian.
Yeah, I mean, it certainly might be helpful. I'm not sure they're really necessary in a lot of cases. If I'm looking at it as if do I want to have a guardian, why would I want one? I may want a guardian to serve sort of as a case manager to coordinate an array of evaluation and treatment services and manage the social aspect of the case so that we can get to a resolution of the legal issues. Or I may feel that I've got a very difficult time developing good information. And so I really need a guardian to be a factual investigator and go bring this information to me so that I can make a good decision. Those are kind of the two primary roles where I'm looking for a guardian. And when people come, the parties say, well, we want to have a guardian to evaluate us and come up with a recommendation about custody and visitation and so forth. Then I'm likely to say, have you talked to Mark Ashworth, who's the head of the Family Court Services part of DRO that manages the guardians, and does he think this is a case, based on your representation, that they could really help with, or do they think there really isn't a lot that they could do? If I've got lawyers who can certainly marshal evidence and bring it in, then there's a lot less reason to say, why do we have this third party going out and doing the same work? Because you could bring all that evidence in, I can hear it. The guardian is not a shadow judge. They're not there to say, well, I've heard all this evidence and here's what I suggest you do. So it really needs to be a function that they can bring that otherwise wouldn't be available to the case, if that makes sense.
I agree, and I would say I prioritize by family violence cases, in my opinion, really need a guardian ad litem. Cases of significant alcohol and drug addiction, cases where it's difficult for the court to really understand what's happening outside of the courtroom and outside of just what is received in evidence. Those are the cases that I typically appoint guardian ad litem, sometimes by request and sometimes not by request. And those are the cases, as I understand, Mark Ashworth's office prioritizes as well. I'm pretty realistic by this point that they just don't have time to, they don't have enough bodies, they don't have enough time to help in all of our cases. So the domestic violence cases are the ones, anytime I really want to know whether this child is safe with one of these parents. I really want someone to go do that home study, do that drug testing, random drug testing. That's where I really like to have a guardian ad litem at play, someone who can receive those results, do that independent investigation, and then report to the court what they found. Not because they're a shadow judge, I think that's absolutely right, but because that is good information for the court to weigh along with everything else. But the other part of the analysis, that will be a lot of your clients. But some of the people that come in our courtroom can afford a guardian ad litem on their own, or a custody evaluator, and those aren't the cases where I'm appointing guardian ad litems, not where they've got two good, lawyers that are retained and can do the investigation on their own. Those aren't typically the cases where we're appointing, but you all will see a lot involving domestic violence and drugs and alcohol, and claims, maybe competing claims of abuse of the child. Those are hard, and it's really important, I think, to have a guardian ad litem involved in those cases to look out for the interests of the child.
What is your policy about ordering testing for alcohol and drug abuse when I guess all that's really made is an allegation and there is not hard proof through convictions or arrests that somebody may or may not have those issues? Will you all order frequent ongoing testing or not?
Well, I came up with this, and it was the only way I could think is the fairest way to do it and avoid abuses on either side. And that is, let each of the parties sort of be the watchdog of the other. And so I'll say either parent can demand that the other submit to a random test. And the person requesting it fronts the cost. If the test comes back positive, then the parent testing positive reimburses them for the cost, and then they front the cost of the next test. And as long as they keep testing negative, then the parent that's requesting will pay for it. That way, you don't have somebody saying, well, I'm going to demand you go every single day and take a test, because these things are not cheap. So there's some incentive for that parent not to incur a huge amount of cost if this other parent really isn't using drugs or alcohol or abusing it. On the other hand, if they are, then they should bear the cost of that. So that's one method I've come up with, and it seems to work reasonably well. For more intensive types of cases, there's a technology called SoberLink, which can be used, and the person has to blow into a device that monitors their alcohol level. I think it's just alcohol testing with that. And then if they test positive, that's reported, and so that's a pretty effective monitor. Now, being drug-free or not drinking doesn't mean that a person is in recovery. And if they are dependent on alcohol or substances, then merely refraining from that isn't necessarily going to solve the underlying problem. They really need to be actively engaged in recovery too. But I think the question was, well, we got allegations, there isn't really any big evidence that anything has happened, then, you know, that's the way I came up with, is sort of balance the interests. And if you want to ask this person to submit to a test, you can, but you got to be willing to pay for it until they show you otherwise.
What if you have something else that's not just the other party's allegation? Like, you know, you have DWI, DWI conviction, or you have some kind of arrest record or police report that shows that the person's been using drugs or anything like that. Do you then make the party who's interested to have the other party tested bear the cost, or is that a different situation?
Well, I think it depends on what the evidence is going to show. How serious is the problem, and what is the correct approach to it? Here's the but here's the other problem. Let's say you have the person who had the DWI. All right, we're going to demand that you submit to random tests, but you got to pay for every single one of them. Then what's the incentive to say, well, I can't ask you for a test every single day or 2 or 3 times a day? You know, that gets exorbitantly expensive. And you could say, well, you can only ask for a certain number within a certain period of time, but then it becomes a lot less random. And I think the only effective testing really is random. It's got to be a surprise on short notice, because otherwise a person can evade it, really. So, you know, if there are demonstrated evaluations or evidence showing this person really has a substance abuse or dependency issue, then they ought to be in treatment, and they ought to be following that treatment plan, and that may involve ongoing monitoring. And so that may take it completely out of what I just described, which is my sort of basic, well, you know, this parent smokes marijuana, you know, and they say, well, we were doing it together the whole time we were married, and it never was a problem then, now suddenly it is. And so that kind of thing, or casual use that I'm not sensing that anybody's offered any evidence that this is impairing the kids, then that's my best safeguards. All right, well, you think they're using, ask them to submit, and if they're positive and you're right, then they're going to be paying for it, not you. But if you're wrong and they're really not, and they're staying clean, then
Yeah, I pretty much follow that process, but I would say that if I have one party telling me that there is a serious risk of drugs or alcohol impairing the parent during a visitation, I might on the onset order the drug testing be done. The guardian ad litem will do that, and sometimes at no cost to your client, depending on their income level. They work on a sliding scale. So that's another great benefit of Mark Ashworth's office, is that if the guardian ad litem thinks that there is a real reasonable basis for testing, they'll do it, and they'll do it randomly. And that could be, if our primary concern is figuring out whether there's a problem, then they'll do that without regard to cost. But in a situation where they're both, he's doing drugs, she's doing drugs, then usually I'll say, you both go do it at your own expense. And then once we have those results, we can take a look at, all right, well, you came back dirty. And so now on a going forward basis, you're going to be required to test regularly and you're going to pay for it. And so, but again, they're fact intensive. It really, every case is different. And so there's not really a set of rules pertaining to how we do it. But I do like, if you order the test and it comes back clean, then you're responsible for paying for it. I do like that if there's any suspicion that someone is unnecessarily or wrongfully pointing the finger at the other when there's not really anything going on, and that does happen.
Right. And I think just a general rule of thumb, which in these situations, be careful what you ask for, because you're asking for the other client to get drug tests and alcohol tests. Your client's likely to get checked off on that box too, to have drug testing, psychological studies, home studies, those type of things are, it's a two-way street. That it's never, rarely does it just one side have the big problem or the issue. And so, if your client comes in and is candid with you and tells you, we've both got this issue, or we've both been doing this, we've both been smoking marijuana for the last several years, or whatever it is, or consistently, you got to make that decision on whether you want to press on that issue or not. But most of the time, if there's an appointment of a DRO, you'll see that, or an ad litem, the form is going to check off for the DRO to have authority to test both parents. So it's not going to be one-sided in those situations.
Familiarize yourselves with that DRO form and look at what you really want to ask for if your client qualifies for that, and you really think that a guardian ad litem would be helpful in your case. Look at that form and see what it is you really need, and what abilities you want to give that guardian ad litem.
And I'll just throw this in as a detail, you'll notice, but on the form it says the guardian may ask the parent to submit or shall ask the parent to submit. And I always check the shall because it's a funding question, not because I really want them to have to do that. But if the order says may, they have a lot harder time paying for the testing. If it says shall, then it's not a problem, they can pay for it. And so in order to get them paid for, that's why we
Check.
say shall. So that's, even though I may just want them to exercise their discretion, and if they think there's a suspicion, they can ask for the
And just
test.
because you sign the form, or that you fill out the form, doesn't mean the judge is necessarily going to sign that form, but at least suggest to the judge that you think that is something that is necessary.
We've got 4 more minutes. Does anybody have a question they'd like to ask?
This is, I don't know who else to ask, it's a really nuts and bolts question, but the family code says that in the final order, you've got to have a social security number, driver's license. How do you get around that?
I white all of those out if people bring them to me, because I don't want them. They shouldn't be in the clerk's office. The code does say that, but we in Travis County, what is the form called?
VVS.
That form is, the vital statistics form is sufficient for Travis County. We don't want social security numbers being filed on any document, ever.
Well, also, the clerk has the ability to redact the document from public view. And so if you look up an order, it'll have a black band over the social security box and over the driver's license number and over the birth dates and things like that. So you can include that information in the written order. The legislature has mandated it, as you observed. The clerk will redact that information from public view so that in theory, nobody else should be able to access it. Now, I don't know that that's a foolproof system.
It's not.
And there's no guarantee it
Yeah.
won't. And so I think what Judge Crumpus says, there's no sanction for people not including that full information in these orders. And what some people will do is just put a partial number, like you would with a credit card number or something like that, ending in these 4 digits or something. And I mean, nobody is complaining about it. Why it has to be in there, I can't tell you. The legislature decided that was a good idea. But that was before we've had a lot of problems with identity theft and things like that. So I don't think there's anything bad is going to happen if you don't include that in your order.
You do need to designate on the top left corner that it needs to say, notice this document contains confidential information.
That's the best thing to do.
If you don't
because
put,
then
the clerk will not know that so any document that you file, decree, a petition, anything that contains personal information, you need to put that warning in the top left corner, or the clerk won't know to go through and redact it.
Name change orders, any bank account numbers, those are.
We put some scary amount
We
of
do,
personal
and
information.
whenever, most lawyers don't,
yeah.
Most lawyers, the orders I see, most lawyers redact them or put the confidentiality notation on there, but the district clerk's office is fantastic, but I don't recommend that you rely on them catching every, identifying number and social security number and everything. I think that's risky.
You doesn't always happen in all these cases particularly, but if you've got some stuff in the record or in the case that you think is that needs to be sealed, there are family code cases arising under the family code are kind of generally accepted from some of the requirements of 76A. Still have to prove a lot to get it sealed in certain circumstances, but it's not as onerous as the Rule 76A requirement. So you see a lot of that where people want to seal the whole case. That might be an option if you have some type of really sensitive or confidential stuff that you know has made it into the record.
The other thing that some people do on, maybe not for your VLS cases, but if you wind up, if this becomes a jumping board into more sophisticated litigation, then you might wind up with a case where the estate is worth quite a bit, and you don't want to file all the information that might otherwise be contained in the final decree of divorce, and you could certainly incorporate an agreement, either a mediated settlement agreement or an exhibit that's not filed, as long as it's referenced in there and there's an agreement about that. There are means and mechanisms to protect some confidential information, and we're certainly happy to help you do that. So just let us know if there's some particular concern.
That had come up in a VLS case.
It probably won't, but you never know.
Well, I think it's 2 o'clock, and I want to thank you all for being here. We appreciate it.
Thank you.
Absolutely.
We're usually the last ones.
I know.
Hey, thank you.
And Judge Yelenowski wanted me to give you all
I know
a
it's a
hello
splitting question.
and a happy holidays. I'm sorry he couldn't be here today. He had a family emergency.
And I will hold you all to this.
Yeah. Thank y'all for taking cases too and signing up. It's an impressive crowd. It's awesome that y'all are able to take BLS cases.
All right, our next speaker is Mary Evelyn McNamara. She's a partner at Rivers and McNamara. She is a former board member of the Volunteer Legal Services and past president of the Texas Women's Lawyers. She is going to talk to you all about temporary orders procedures.
Thanks, Shane. So I was sitting at the back of the room, and there's an air conditioner back there. Can everybody hear me? Okay, great. First, I wanted to thank everyone very much for volunteering to take VLS cases. The need is always greater than the number of volunteers available, and your help in representing someone who cannot afford a lawyer is fulfilling VLS's mission that poverty is not a barrier to access to justice. So thank you very much. Also, thank you for being here on a Friday afternoon in December when you probably have 47 other things to do. Show of hands, how many folks have handled a temporary orders hearing in a family law case? Okay, not very many. So I will give you a quick run through of how this works, what it's all about. The first thing is the term temporary can be misleading. They are orders that remain in place while the divorce is pending until a decree is entered or until there's a modification of the temporary orders. So many divorce cases and suits affecting the parent-child relationship can last for several months. And so you must expect that the temporary order is going to be something that the parties are living under for many, many months. General subject areas for a temporary order are where are people going to live, how are the bills going to get paid, the schedule for the children, and financial and medical support for the children, preservation of property as in how is the community estate going to be handled while the divorce is pending. Of course, in Travis County, there is the standing order that goes into effect when a petition for divorce or a suit affecting the parent-child relationship is filed. And so that standing order does have many injunctions in it, prohibiting, for example, destroying property or canceling insurance coverage. Also, there can be temporary injunctions in a temporary order going beyond that standing order, and then an information exchange, such as an exchange of sworn inventories setting out all assets and debts. I have put in my paper, and I'm certainly not going to read through them, the applicable statutes for temporary orders in the Family Code. Texas Family Code 6.501 addresses temporary restraining orders in divorces. 6.502 addresses temporary orders in divorces. And 105.001 addressing temporary orders regarding children. So, generally, in family law cases, it is in the best interest of, the presumption is, it's in the best interest of a child for the standard possession order to be put in place. That presumption also applies on temporary orders. There is also a rebuttable presumption that guideline child support applies in temporary orders. And so those are standards for you to keep in mind as you're advising a client about temporary orders. A request for temporary orders must be supported by the pleadings. The VLS forms include a sample motion for temporary orders. And you should set out the pleading in a manner to give fair notice without providing a detail of the facts. And there is a statutory provision in the Texas Family Code saying that pleadings in family law cases shall not include detailed facts. So you don't want to start putting in the kitchen sink as far as the facts, unless there's a situation, for example, I know that you've agreed to take domestic violence cases. There may be a situation in which you're going to have your client's affidavit attached to your pleading asking for ex parte relief. And that if you're asking for an ex parte temporary restraining order, I want you to note these provisions. First, do not repeat in that request for ex parte relief what is in the Travis County standing order. In fact, the local rules say don't repeat that. Travis County Local Rule 23.1 says that. If you are requesting the exclusion of one spouse from the marital residence, you may not make that request unless it is part of an application for protective order. So something important, if your client says, I want the judge to exclude that so-and-so from coming back to the house, well, that's not something to be bandied about lightly. It has to be associated with family violence. If you're requesting that the other party be excluded from possession of or access to a child in an ex parte TRO, you must accompany that request by your client's affidavit. And if you are requesting this, you cannot run down to the courthouse and present this to the duty judge at regular 8:30 or 1:30 uncontested docket. You must make an appointment with the duty judge to present this request for relief. That is in Travis County Local Rule, let me see here, 7.3. And when you have this request and you've made an appointment with the duty judge, don't just run down there with your pleading with the affidavit attached and no client. Have your client with you, because you can expect that the judge is going to want to ask your client questions to drill down on why it is in the best interest of the child or children that there be no possession or access by the other parent. Now, if you're requesting a temporary order hearing before the respondent's answer date, which of course is the Monday following 20 days after service of the original petition, get an order to appear signed by the judge. The language for that order to appear is set out in Travis County Local Rule 26.2. So it's all set out there for you. And have a hearing setting in that order. And then have this order served on the respondent at the same time as the petition. Now, a practice note, and I know this practice note because I ended up being sent away by the judge when I was trying to get a hearing set. You must have the petition on file before the judge will sign the order to appear. I went up with an order to appear. I had the petition in my hand, and everything's electronic at the courthouse, and the judge looked up and said, I don't see that you filed this petition. Go away and come back. After the judge does sign the order to appear, take it to the court administrator's office to get the hearing set. Now, I know that Warren Vavra, the court administrator, talked this morning, and so I won't belabor points that he covered as far as do's and don'ts with the court administrator's office. But in general, the dockets for a temporary orders hearing, if it's going to be 3.5 hours or longer, are Monday settings. And if it is 3 hours or fewer, then that's Wednesday through Friday settings. Those are the family law long docket on Mondays and the short docket on Wednesdays through Friday. And in general, unless the temporary orders issues are particularly complex, the fewer than 3 hours setting should be sufficient for your temporary orders hearing. Now, something that clients need to know is that just because a hearing is set at 8:30 in the morning does not mean they're going to go in right after docket call, get assigned to a judge, have a hearing, and go home. There is waiting around at the courthouse when you are going for a temporary orders hearing, unless you are very, very top of the docket, because there are simply not enough judges to hear all the cases all at once. And so, especially if you're headed into page 3 of the docket, even sometimes higher than that, you're going to be having some waiting around. And I already had this to talk about, and then I heard Judge Hathcock say it, and I'll say it again. Do not have any children at the courthouse for a hearing. Just don't. And you need to talk to your client about this ahead of time, because especially when you're talking about someone who is already living on the edge financially, if they have a 3-year-old child and they've got a court setting, they're just going to come on down to the courthouse with their child because they don't have childcare. And so talk to your client ahead of time that childcare arrangements must be made. And if you do want to ask a judge to interview a child, and the statutory provision for that is Texas Family Code 153.009. Read that statute, make your motion, but again, don't have a child anywhere near the courthouse. It is a frightening place for a child to be, and they just don't need to be there unless ordered by a judge. So docket call, Mondays, Wednesdays, Thursdays, and Fridays is at 8:30 in the morning. I'm going to cover something that I have twice in my paper because it sets off judges very fast. Turn off your phone. Turn off your phone, or turn off your ringer at least. Put it on silent when you get to the courthouse, and instruct your client to do so also. I have found myself in situations in which I forgot to instruct my client, the phone goes off, and I'm just ready to crawl out of the room. The courtroom where docket call will be held is posted on the monitors on the first, well, on all the floors now. But I'll tell you, if you're not familiar with the system, it's not going to be helpful to you as you look up and the monitor says HA1. That doesn't tell you anything, and so you can also go to the court administrator's office, the information desk, and ask, where's the family law docket call going to be held? Make your time announcement when called. That's all the judge wants to hear is, are you ready, and what's your time announcement? And if you have a motion for continuance, you can say, I'm requesting a continuance. If the parties are conferring about an agreement, ask that your case be placed on recall. And after docket call, in the most likely event that you're not immediately assigned to a judge, make sure that the court administrator knows where you are. The person who generally handles family law court administration, especially on Wednesdays, Thursdays, and Fridays, is Jacob Stokes. And so learn who he is, make sure he knows where you are in the courthouse so that he's not walking around calling out your client's name and then skips over you and moves on to the next case because he can't find you. If you have proper service on the respondent and the respondent does not appear, you may ask for default temporary orders. Have your proof of service and make sure it's on file with the clerk's office. And I'm going to skip ahead a little bit to talk about defaults. I think in every single talk I give about family law procedures, I remind people that a default still requires evidence. It's going to go faster, of course, than if you have opposing counsel or at least an opposing party, but a default requires that you put on the proof through your client and any exhibits you have for the relief that you are requesting. Now, I mentioned if you have a continuance, let the judge know. Sometimes there are situations in which if you're asking for a motion for continuance, you're raising it that morning. But the general rule for continuance is the request for continuance is it must be set in family law cases on the docket at 1:30 on Thursdays. And if you have a Wednesday, Thursday, or Friday setting, you set your motion for continuance on that Thursday the week before the setting. If you have a Monday hearing setting, you set your motion for continuance on the Thursday that is the previous week. So essentially 10 days before a Monday setting is when you would have a motion for continuance on the Thursday at 1:30 docket. Again, with VLS clients, generally these are people who have never been in a court situation, or if they have been in a court situation, it has been frightening, such as in the criminal context. And so they're not going to necessarily view the courts as a good place to be. They may know absolutely nothing about rules of decorum. And so you have to assume when you're dealing with a VLS client and you're taking that person to court that they are going to need to know how they should dress. And by the way, that doesn't mean they need to go out and buy a new outfit. They just need to be dressed respectfully. And as far as behavior in the courthouse. Usually an associate judge will preside over a temporary orders hearing. Judge Hathcock, who was presenting in the panel previously, is an associate judge, and you would generally have Judge Hathcock, Judge Sines, or Judge Arth, sometimes Judge Aurora Martinez Jones, presiding over a temporary orders hearing. So, required exhibits in temporary orders. Under Travis County Local Rule 23.4, there is a pre-trial procedure before any temporary or interim orders hearing that requires that if child support or spousal support, temporary spousal support, is at issue, that your client, each party shall prepare and deliver a proposed support decision form. A proposed support decision is a summary listing of a party's income and expenses, as well as areas for statutory calculations for deductions before calculating child support. I have the form attached at the back of my paper, and it is also available online at the Travis County Court's website. You deliver the required form to the opposing party and the judge hearing the case before the case is called for hearing. And if you do not have that, there are some printed forms at the courthouse, but you sure want to have gone over this with your client ahead of time to lay out that person's income and expenses. And now, with VLS clients, when you are filing your case, you will have assisted your client in filling out the affidavit of inability to pay costs. And so that is a good starting point for the proposed support decision for your client, because it sets out that person's monthly income and monthly expenses. Now, I talked about the statutory presumption, a rebuttable presumption in favor of guideline child support applying to temporary orders. There are no statutory guidelines governing temporary spousal support while a divorce is pending. Temporary spousal support is intended to protect the financially dependent spouse while the divorce is pending, and is based on the duty of each spouse to support each other under Section 2.501 of the Texas Family Code. Temporary spousal support can be in the form of a direct cash payment or payment of certain expenses such as rent or utilities or a car payment or car insurance. The child support calculation that you will be making in a request for child support is going to be based on the following Texas Family Code sections. 154.061, which is the Texas Attorney's tax chart that is promulgated each year. You can also find that tax chart on the Office of Attorney General's website. 154.062, which defines what net resources are for determining child support, and 154.125, which governs the application of the child support guidelines to net resources. Under Texas Family Code, Section 154.068, in the absence of evidence of the obligors, that is, the person who's paying child support net resources, the court shall presume that the obligor has income equal to the federal minimum wage for a 40-hour week to which the support guidelines may be applied. And in fact, on the Attorney General's tax chart, there is an asterisk next to the income amount that is based on that 40-hour week federal minimum wage. Something that is very helpful for judges that is not required in a temporary orders hearing is a proposed disposition of issues, which is the outline of relief that you're requesting. I give this to a judge every time I'm in a hearing to request relief, because you know that old saying, if you don't know where you're going, any path will get you there. If you have an outline of the relief you're requesting, first it says that to the judge, and you know, I've actually seen judges sit there and I check or XXX on the summary. But it also gives you the outline to follow for putting on your evidence during the hearing. You can also have a proposed form of temporary orders ready to go to present to the judge, which will save you time after the hearing. I will have a proposed form of temporary orders, give it to the judge, and of course it's a rare day when a judge orders every single thing in the proposed form, but still you have it there and the judge can interlineate, cross out, and then you have your temporary orders there that day without having to go back to court. Typical witnesses in a temporary orders hearing are going to be the parties. If family violence is an issue, a corroborating witness may be helpful if you don't have something such as a police report. If custody is in dispute, you can have friends, neighbors, and family members talk about the abilities of the parents, but in general, judges really only want to hear from the parties. And if you have an ancillary witness, keep that person's testimony short. If you reach an agreement without the need for a hearing, read your agreement into the record. Manage your time wisely. You will not have enough time. You just won't. And the judge keeps very careful track of time for each side. Inform the judge of all stipulations and agreements before introducing any evidence. And unlike a final trial, in a temporary orders hearing, your opening statement is going to be pretty brief, maybe expanding just a little bit more on the proposed disposition of issues. Generally, judges do not allow closing arguments at temporary orders hearings. The judge will rule at the end of the hearing, may take a break for a few minutes to review some information, but in my experience, every time a judge rules at the end of the hearing, now watch, somebody will have a hearing here and they'll say to the client, well, I know the judge is going to rule at the end, and it doesn't happen. So, you know, nothing is absolutely certain when you go to the courthouse. If a party is unhappy with an associate judge's ruling on temporary orders, that party can file a request for a de novo hearing before a district judge. Know that unless an associate judge's ruling is out of the norm, a district judge is usually not going to change the orders of the associate judge. The request for a de novo hearing must be filed and served no later than the third working day after the associate judge issues it's the substances of his or her rulings. So, that does not mean 3 working days after the judge signs the temporary orders. That means 3 working days after the judge issues oral rulings from the bench. The request must specify the issues to be presented, and any other party may file a request for a de novo hearing by the 3rd working day after receiving the original request. The de novo hearing must be heard within the 30th or by the 30th day after the original request is filed. Also note that under Travis County Local Rule 22.5, the request for a de novo hearing must be filed with the court administrator's office on the same day that it is filed with the district clerk's office. So that is a really quick run through on temporary orders hearings. I have about 1 or 2 minutes if anybody has any questions. Okay, thank you very much.
All right, we have a 15-minute break. Our next speaker will be here at 2:45.